Hello friends, welcome to this series in which we are discussing the multiple choice questions on Indian polity. Today we are going to discuss 10 multiple choice questions on the topic Attorney General of India. This is an initiative of the Nimbus Academy based in Chandigarh. You can download the Nimbus Academy app from Google Play Store or Apple Store. You can also follow us on Facebook. You can also join our Telegram group. You can also WhatsApp us on this number to get all the free material, including the daily tests, daily quizzes, current affairs videos, etc. So let us start. The first question is, which article of the Constitution of India establishes the office of the Attorney General of India? The options are A. Article 74, B. Article 75, C. Article 76, or D. Article 78. The correct answer is C. Article 76. So, Article 76 is mentioned under Part 5 of the Constitution, which is the part of the Union, and Attorney General of India is a part of the Union Executive. So, it is mentioned under Part 5, Article 76 of the Constitution. Second question, who appoints the Attorney General of India? Options are A. Parliament in consultation with the Prime Minister, B. Prime Minister in consultation with the Union Council of Ministers, C. President in consultation with the Parliament, or D. President in consultation with the Union Council of Ministers. The correct answer is D. President in consultation with the Union Council of Ministers. So President is the appointing authority of the Attorney General, and as we know, President does not make any appointments in his own discretion. He has to consult the Union Council of Ministers, which is the real executive, and the advice of the Union Council of Ministers in such regard is binding on the President. Third question, which of the following is not an essential qualification for a person to be appointed as an Attorney General of India? The options are A. He must have been a judge of some high court for 5 years. B. He must have been a legal advisor to a state government for 10 years. C. He must have been an advocate of a high court for 10 years. Or D. He must be an eminent jurist in the opinion of the President. The correct option is B. He must have been a legal advisor to a state government for 10 years. This is not a valid criteria for a person to be appointed as an Attorney General. Among all the other three criteria, either of the criteria has to be fulfilled, and these three are the same criteria required to become a judge of the Supreme Court of India. Fourth question, what is the tenure of the Attorney General of India? The options are A. 2 years, B. 4 years, C. Co-terminus with the tenure of the central government, or D. None of the above. The correct answer is D. None of the above. So the tenure of the Attorney General of India is not fixed. It is neither co-terminus with the tenure of the central government. It may happen that the government may change, but the Attorney General remains the same. It depends upon the wish of the new government whether it wants to change the older Attorney General or to continue with the same person in the same designation. So none of the above is the answer. In general, the Attorney General of India serves according to the pleasure of the President. And pleasure of the President means the wishes of the Prime Minister and his Union Council of Ministers. Therefore, as long as the government desires, the Attorney General of India remains on that post. Fifth question, which of the following is not a function of the Attorney General of India? The options are A. To appear on behalf of the Government of India in the courts. B. To give advice to the Government of India on legal matters. C. To advise the President under Article 143 of the Constitution on matters of law and fact. D. To discharge the functions conferred on him by the Constitution or any other law. The incorrect statement is C. To advise the President under Article 143 of the Constitution on matters of law and fact. The Attorney General does not directly advise the President, that too under Article 143. This particular right or duty has been conferred on the Supreme Court of India. So the Supreme Court of India advises the President on matters of law and fact under Article 143 of the Constitution, and it falls under the advisory jurisdiction of the Supreme Court. So the President can seek the advice of the Supreme Court on matters of law and fact under this particular article, and the Supreme Court is bound to provide such advice. But this advice is not tendered by the Attorney General of India. However, in such cases where such advice has been asked for by the President of India from the Supreme Court, and if such case is contested in the Supreme Court, the Attorney General represents the central government in the Supreme Court. Sixth question, what is the remuneration of the Attorney General of India? Options are A, 2 lakh per month, B, 3 lakh per month, C, 5 lakhs per month, or D, none of the above. The correct answer is D, none of the above. The Constitution does not specify the remuneration to be paid to the Attorney General of India. It is to be decided by the Prime Minister headed by the Union Council of Ministers, and it is not defined under the Constitution of India. Seventh question, which of the following rights is not enjoyed by the Attorney General vis-a-vis the Parliament of India? So the Attorney General enjoys all the rights and immunities of the Member of Parliament, but which of the following rights is not enjoyed as under that particular privilege? The options are A, right to take part in the proceedings, B, right to speak in the Parliament, C, right to attend the proceedings of a parliamentary committee, or D, right to vote in the Parliament. So the right which is not enjoyed by the Attorney General is the right to vote in the Parliament. Since the Attorney General is not a member of either House of Parliament, so is not an MP. Therefore, he does not enjoy the right to vote, but he can take part in the proceedings of his Parliament, he can speak in the Parliament, and can attend the proceedings of a parliamentary committee of which he or she is a member. Eighth question, choose the correct statement. A, Attorney General is a full-time counsel for the government. B, Attorney General falls in the category of a government servant. C, Attorney General is debarred from private legal practice, or D, none of the above. The correct statement is none of the above. So all the statements are incorrect. Attorney General is not a full-time counsel for the government. Attorney General does not fall in the category of a government servant, and Attorney General is not debarred from private legal practice. So all the three statements are incorrect. Ninth question, which of the following is a constitutional office? Options are A, Attorney General of India, B, Solicitor General of India, C, both A and B, or D, none of the above. So let us see how to solve this question. Now we have already discussed that Attorney General of India is mentioned under Article 76 of the Constitution of India. That means at least this office is a constitutional office. So it could either be option 1 or both A and B, but it cannot be none of the above. So this much we are sure. Now Solicitor General of India is also not mentioned under the Constitution of India. Therefore the answer is A, Attorney General of India. 10th and last question, which of the following is not a legal limitation placed on the Attorney General of India? A, he cannot defend accused persons in criminal prosecutions without government's permission. B, he should not advise or hold a brief against the government of India. C, he should not accept appointment as a director in any company without the permission of the government. Or D, he cannot continue private legal practice while holding the office of the Attorney General. So which of these is not a limitation placed on the Attorney General? The answer is D. The statement says he cannot continue private legal practice while holding the office of the Attorney General. But this statement is incorrect because he can continue private legal practice. However, such private legal practice should not in any way conflict his role as the Attorney General of India. So that is proven by these first three statements. So he cannot take up any criminal case in which he has to defend the accused without the permission of the government. He cannot take up the post of a director in any company without government's permission, and he should not advise or hold a brief against the government of India in any other private case he or she may indulge in. So, subject to these limitations, the Attorney General can continue private legal practice and is not debarred from it. So thank you everyone. I hope you like the questions. Do like and subscribe our video and share it with your friends. Thank you for watching.